This is part 3 of a video reading to you a motion I filed with the 3-judge panel in Ramsey County appointed by the Minnesota Supreme Court. I want to void their action because they're usurping the role of judges in this election contest, which violates the United States Constitution. It also violates Minnesota election law, and I'm going to start off reading about Article 1, Section 4 of the United States Constitution because, as I've explained to the Minnesota Supreme Court, this requires them to fulfill their role of enforcing the prescribed, that means established in advance, election laws during an election, and not just run off and let people do whatever they want once the election starts, because it's allowing intense partisan destruction of our Constitution. This extremism that shifts in Washington and polarizes the entire nation flows from states not enforcing the laws set up in the Constitution. So Article 1, Section 4 of the United States Constitution places on all parts of Minnesota state government, including this panel and the Minnesota Supreme Court, the absolute requirement that the state conduct elections for the U.S. Senate and U.S. House of Representatives according to the time, place, and manner prescribed by the state legislature. That time, place, and manner is to be found in Minnesota's code, including but not limited to Minnesota Statutes 200 to 212, and as is relevant to this contest, the Minnesota Government Data Practices Act as well. And the importance of that is, which in particular requires that unless the legislature has specifically classified these voter email addresses, which Mark Ritchie collects as non-public, and they have not so classified them, they are presumed to be public. So this relates to the voter email ground. The state is also bound by other elements of the U.S. Constitution and applicable federal statutes, such as the equal time requirement, which Al Franken and the broadcast media violated, for publicly broadcast debates of the Federal Communications Act. So this is in that Federal Communications Act of 1934 as amended. See the debates ground for the contest. Now, and I want to stress that these are grounds. These are not merely claims of me. This is an election contest, which is not based on the count or fraudulent voting, but the validity of the election according to the principle clearly stated by the Minnesota Supreme Court in the Sari versus Gleason case spelled out in the amended complaint. This panel has no authority to reduce these grounds to personal claims. In fact, since these are reserved for the Senate in the first instance, only the Senate could have received and acted on these grounds. The panel is playing as if you are the judges, while the sole judges are the Senate. Furthermore, these grounds are not mooted by the handling of the case, either for the court's judicial review of the conduct of the contestees in the Minnesota courts. It is critical that this panel and the Minnesota Supreme Court review this matter and show how the law and Constitution were in fact followed or not, and that the U.S. Supreme Court have the chance to rule on the constitutionality not only of the full U.S. Senate's action, but also Senator Franken's and the state officials. Lurie Swanson, through Nathan Hartshorn, Governor Date, and Mark Ritchie, and any further action by Steve Simon and his successor need to be reviewed. In addition, the U.S. Senate needs to get the evidence the panel has suppressed about Franken's right to office. And for this, the panel should review his quashing of discovery, already started by contestant, and reopen the contest and allow full collection of evidence by all sides. I'm not looking just for something to benefit me individually or partisanly. Now, validity of the election boils down to this. Did Senator Franken and Mark Ritchie, as officers of the DFL and in their official capacity, respect the rights and responsibilities of all the voters and of their opposing candidates and opposing parties, including the right to nomination by contestants statewide Independence Party primary, and the equal status as a major political party under the prescribed state election laws of the Independence Party? Or did they scoff at the party in opposition? Did they seek to annihilate this party and candidate as if it did not exist, nihil? Clearly, the election, with their conduct and the conduct of the Minnesota courts, refusing to even entertain enforcement of key First Amendment requirements was an invalid election, a sham. Now what happened in the panel proceedings? This panel, at best, is apparently totally confused on the requirements of an election contest for congressional office. At worst, they deliberately refused to apply any of the law except the part they wanted to follow, which was to render the entire election contest proceeding a nullity and an absolute farce. The evidence of record in the proceedings so far strongly suggests they just deliberately undermined the proceedings necessary to conform with the law and Constitution, apparently because of the great legal and personal and political superiority they feel over contesting. It was presented to them exactly who the judges in the contest are, and that it wasn't them. Yet they concocted, again, scrolling up, yet they concocted a procedure consisting of hearing motions to dismiss from Al Franken and Mark Ritchie, over which they were the judges of some civil motions which are not only irrelevant, but totally impossible in the procedure. There simply cannot be any motions to dismiss in this elections contest. There's nothing to dismiss. The idea that Mark Ritchie had to spend the panel's time and the contestants' time getting dismissed as a party is utterly ridiculous. It was only important for contestant to recognize, I believe correctly, that Ritchie was a party, so that I needed to timely serve him. Even if he was not a party, because the implicit question of taking away the IP major status as a result of the automatic operation of the law still requires he be furnished with the contest and that he appear through the Attorney General to represent the state's case. To the degree the question of IP major party status is seen as not voted on in this race, the net result is merely that Al Franken is the only contestee. The serious, material, and deliberate violation of election laws still remains. The issues regarding the validity of the election still remain. They are not dismissed because, quote unquote, because Ritchie refuses to consider there was an implicit question, not ballot question. Nowhere have I ever said it was a ballot question, but it was folded in. Now it is clear what this panel was supposed to do, and the judgment is void because they simply obstinately and arrogantly refused to do it, and instead pretended they are empowered to usurp the power of the U.S. Senate itself, including Al Franken, who behaved unethically as a judge in his own case. Senator Al Franken, who literally wrote the book, a bestseller, which he titled Rush Limbaugh is a Big Fat Stupid Idiot, by Al Franken. It is probably the most clearly partisan book known to humankind, since Limbaugh is a widely known conservative Republican. And outgoing Secretary of State and Chief Elections Officer Mark Ritchie, who was admonished by the legislative auditor for having denied that he brought home at least 600 email addresses of voters and donors generated by the official work of OSS, in other words, official resources, for fundraising and electioneering use by him and his campaign voters for his own DFL Chief Elections Officer campaign and Democrats. There can be no doubt he is highly partisan, are both widely known as highly partisan Democrats. In the proceedings of this panel, Senator Franken knew that once he and Ritchie procured, by hook or by crook, a vote to seat him in the 114th Congress, any further review of his seating by any court, including this one, or the United States Supreme Court, would be moot, except for the constitutionality of the Senate action or this panel's action. No one, Senator Franken reasoned, and Ritchie backed him, must examine the validity of this U.S. Senate election or the destruction of the DFL and GOP foe, the Independent Voters of Minnesota, organized as a major party in the Independence Party of Minnesota. So he obtained his Senate seat by fraud, by intrinsic fraud, and by multiple violations of due process in this panel's proceedings, and extrinsic fraud by presenting himself with a certificate of election he knew or had reason to know was obtained in violation of due process and the requirements of Minnesota law. He actually cleverly used his interference and illegal actions in these proceedings to shield himself from questions about his right for office and to quash the interrogatories I had served on him while awaiting the Supreme Court's required action of appointing this panel. sweet, but highly dangerous to American democracy in Minnesota and elsewhere in the Union. So this is a clever entertainer who is sitting now in Washington representing Minnesota based on a fraudulent election and a fraudulent election contest. Now, relief from this panel's unauthorized action, because the judgment is void, is clear on the face of it. The panel, as it were, danced with this Democrat darling around any possible due process, because even a strong resemblance to faithfully carrying out the state law under which this panel was convened ran the risk of actual evidence of invalidity being collected and forwarded. The evidence presented, and much more which this panel has wrongfully eliminated, shows this was an invalid election, so that even if under law he is entitled to the certificate, he may not assume office because it must be a valid election. See Sorry versus Gleason, Minnesota Supreme Court case in the amended contest. Key to the operations of this panel and the Minnesota courts is in this contest is Article 1, Section 5, which was clearly presented to the panel in the oral argument. And again, having to flip up here, I have a very difficult scroll bar, was presented to you in the oral argument at the brief so-called trial held December 18, 2014, according to the order of the panel, and is presented again for your consideration and submission to the federal Constitution. Referring to Morgan Supra, a contestant very clearly explained to the panel that no court, and certainly no Minnesota court, may sit as judges of the contest brought before you. Senator Al Franken, however, under that constitutional provision and precedent, is a judge of his election, because the judges consist of the U.S. senators, not this panel. This is very key, and the panel simply ignores democracy and the U.S. Constitution if you ignore these two things. Such action would be unthinkable. A further corollary of this fact of Section 5 is that it would be completely improper for Al Franken to sit as judge of his own case. And yet, in response to this contest, Judge Franken, Democrat, and the Chief Elections Officer, Mark Ritchie, Democrat, represented by Assistant Attorney General Nathan Hartshorn and Attorney General Lori Swanson, Democrat, urged this panel in a December 16th letter never presented to contestee until after the so-called trial on December 18th, not to follow the Minnesota law or the United States Constitution. This panel has not yet followed either, and as a result of Franken's, Ritchie's, and this panel's action, on December 19th, 2014, just one day after the show trial, and before contestant received any judgments, and before I had even briefed all the issues, Governor Mark Dayton relied on this improper panel action to take the initiative to send a cover letter to the Secretary of the Senate, along with a certification that Franken had been quote-unquote selected by Minnesota. The strong implication of that language is that some selection had occurred compliant with the U.S. Constitution's mandate that the time, place, and manner of selection by the state legislature had been followed, when it had not. The certificate and cover letter also withheld the fact that these state officials have in fact knowingly and willfully usurped the power reserved for the U.S. Senate and gone ahead and made findings of fact and conclusions of law on the contest that was in fact presented to the Minnesota courts pursuant to Minnesota election laws. And on that, moreover, all the state officials violate the state's own law that while a contest is pending, the Senate may not receive the certificate. Clearly, all these state officials, including this panel and Judge Franken, are acting as if no contest existed. This undercuts faith in the integrity of the judiciary and also undermines the democratic framework of the United States. This is Minnesota Statutes 204C.40, Subdivision 2. Quote, time of issuance, certain offices, requires that in case of a contest, an election certificate shall not be issued until a court of proper jurisdiction has finally determined the contest, unquote. As such, the wrongful action of this panel was the finding it somehow conveyed to contestees and the Secretary of State, Minnesota Governor, that according to its findings of fact and conclusions of law in a contest, Judge Franken was entitled to the issuance of the election certificate because of the false premise that his right to office was unquestioned, uncontested. In other words, Judge Franken, Secretary Ritchie, and this panel, constituted by the Minnesota Supreme Court in a Senate contest, have created, deliberately or not, the illusion, the false perception that under Minnesota law, Senator Franken has a right to office, when that has not happened. Then, in addition to this farcical trial, whether Al Franken really received the highest total of votes legally cast, these same parties, including this panel, tried whether or not Mark Ritchie participated as a party or as a Secretary of State in a Senate contest, and on the basis of this trivial matter pretended no contest existed. This is the machinations of a few depriving the people, jealous of our rights, of our free and fair elections for the U.S. Congress. And while you apparently would have the power to do this for state senator and state representatives, you are utterly lacking in the authority to carry on this way. Worse, you have sullied the proceedings. At the Senate, where Franken sits as a judge, and also a member of the Senate Judiciary Committee, who occasionally chaired it in his first term. And that committee oversees civil rights. Now, I'm going to talk a little bit about now what Al Franken says about civil rights. Franken's website says, although he's not a lawyer, and he happily finds most Minnesotans aren't and can't protect their voting rights, he uses his spot on the Judiciary Committee, quote, to ask the common sense questions that regular Minnesotans would ask and ensure that someone was looking out for how these issues affect individual civil rights. So this is what Al Franken says on his websites. But this is how Al Franken acts and violates the law and Constitution in his own trial. So his conduct is particularly egregious. Ritchie's gimmick that there was some question of whether a ballot question was voted on regarding the automatic operation of law flowing from the election results, terminating the Independence Party major party status, simply does not end the contest. Further, Ritchie himself, in a submission to the Minnesota Supreme Court, January 5, 2015, admits that, quote, Senator Franken's right to hold the office of U.S. Senator remains, as both Article 1, Section 5, Clause 1 of the U.S. Constitution and Section 3 of Minnesota Statutes 209-12 provide, a matter for the Senate to decide, unquote. Except that this panel improperly withheld it from the Senate. And this happened because Franken and his attorneys asked you to do this. I objected and said the contest cannot be severed in this way. And now even OSS admits I was absolutely correct on this. And he and Franken deliberately misled this panel to violate and render a nullity Minnesota election law in the U.S. Constitution. And yet, in the Minnesota Supreme Court, Ritchie argues, in his notice of appeal, appellant repeatedly expresses the mistaken belief that the trial court's holding regarding Senator Franken's entitlement to a certificate of election constitutes a ruling that Senator Franken has the right to the office of the U.S. Senator. Again, he and Franken deliberately arranged for this evidence regarding questions to be suppressed, obstructed in your pen, and you did so. The action by Justice Cites issuing an order, which I did not receive until January 5th, for the parties to brief and appeal on the limited issue of your preliminary order. And I think I have this footnote, and I'm just kind of jumping around it. Apologize for that. And I'm just gonna kind of start this over a little bit. Okay, January 5th. So somehow they were supposed to get this briefing on January 5th, and so somehow on January 6th, the Minnesota Supreme Court might have been able to call up the Senate and recall the issuance of the certificate. That's hardly serious, because this panel, without my knowledge, had issued an incomprehensible order which Ritchie and Dayton took as a pretext to provide the election certificate to the Senate way back on December 19th. The contest was still pending and was not before the Senate, which even Ritchie admits inside here was its bailiwick under Section 5. And so, again, I do apologize. Now, and the relationship between these two parts of the statute, when considered with Minnesota Statute 204 C.40, could not be more clear. Each part, sentences 1 and 2, and sentence 3, each part of this are concerned with Senator Franken's right to office. If he's entitled to the election certificate, that has to do with his right to office. That's what all you think it is about. And if there are questions regarding his right to office because of serious, deliberate, material violation of Minnesota election law, then that also concerns his right to office. And yet, somehow this panel took it upon themselves to withhold serious, deliberate, material violation of election law, including the U.S. law and Constitution, which raised in a contest questions regarding Franken's right to office. Instead, because the questions are clear indicia of a contest, Section 204C.40 clearly directs that the certificate not issue to the Senate. And yet, on December 19, 2014, of which the panel again did not think enough of me to make contestant aware, Ritchie and Governor Dayton did issue that certificate while the contest was pending. At best, this panel bungled the requirements of the law, and all the evidence, including the panel's initial statement, "Let's get this railroad started," at the outset of the purported trial, indicates it was a deliberate affront to the people of the United States, making a travesty, once again, as in 2012, of the election laws required by Section 4, to be prescribed and then adhered to during the course of the congressional election and contest. Here's the origins of this election contest. As presented as sworn evidence in the December 18, 2014 event the panel refers to as a trial, the origins of this 2014 contest began during the Minnesota State Fair, shortly after contestant won a statewide primary to become, whether or not the Independence Party members approved of it personally, the nominee, representing the Independence Party and the rights and interests of the independent voters, independent of the Republicans and Democrats on the panel and in state government, through the statutory vehicle of the major political party, Minnesota Independence Party of Minnesota. In a footnote, the Independence Party has, and the DFL and Minnesota GOP have disrespected and seek to annihilate and believe they have accomplished through this election and contest legal equality with the other two major political parties. We're really no different in that respect. And this point has actually even been made by Hannah Nicollet when she was threatening to sue about our treatment. Thus, the threshold vote percentage of 5% is as legally material an outcome of the Senate elections as choosing the candidate with the highest total of votes legally cast. And again, the panel's finding that Franken received the highest number of votes legally cast is redundant, contrary to law, and a farce, since there was no contest on that matter. And where there was no contest, the certification was effective by automatic operation of law based on the unchallenged actions of the State Canvassing Board November 25, 2014. However, that certificate may not be forwarded to the Senate as long as there is a contest, and there was. This action is judicially reviewable by the courts and has been appealed to the Minnesota Supreme Court, but I'm asking you, as part of the entire judgment, to just void and vacate it. So jumping back on this, so due to the automatic operation of law flowing from that very vote under subdivision 7D of Minnesota Statutes 200.02, which provides that, quote, a major political party loses major party status as of December 31st following, if, in this case, the contestant fails to receive the number and percentage of votes 5%. This matter is part of the actions of this panel, which I allege have been highly improper and wholly unauthorized and in serious conflict with the United States Constitution and its regulation of the state's election of a United States Senator, so that Franken's election is invalidated by it. Every ground in the contest, which has certainly not been even seriously entertained by the panel, but unconstitutionally blocked from reaching the U.S. Senate and Judge Franken's other colleagues, and he should recuse himself from the decision, but absolutely trampled the contest proceedings, rendering them a nullity. Every ground also impacts the threshold vote of 5%. And Ritchie's pretensions that he is not involved in this, or the case cannot go on if he is named as a party, are completely trifling and frivolous. Ritchie was served not because of some threshold requirement that there be a ballot question, or any statewide question at all, or even because he might be considered a party, but simply because he is the officer who is responsible for issuing that certificate, which he illegally did. Now, as a matter of fact, the automatic operation of law has already been altered by the action of the Minnesota Supreme Court and this panel and its stay of judgment, which certainly extended the major party status of the Independence Party beyond the statutory date of December 31st, 2014. And this is true even though the panel, as contestant made very clear to you, December 18th, usurped the powers reserved for the United States Senate and impermissibly reached findings of fact and conclusions of law reserved for them. Previously, the same DFL, but including Representative Betty McCollum, CD4 Minnesota, took actions which led to an election contest arising from the 2012 election, which contest was aborted and ignored unconstitutionally by Minnesota courts. That left unresolved several grounds, which are also present here. Such grounds should have been able to be brought to the Minnesota Supreme Court in an elections petition under Minnesota Statutes 204B.44. But before that could happen in 2014, Judge Franken began engaging in a campaign, and again, I've jumped down here a little bit, and I need to return to up a few pages. And again, I apologize. I have a difficult computer. I've had what are called technology problems. But here we go. I believe I'm here. Judge Franken, before I could bring these issues to the Minnesota Supreme Court, which is, please give me the voter email addresses so I can campaign on equal ground with the major parties without 30-second sound bites, without spending any money, taking the money out of politics. And please say that it is unconstitutional to have gender, race, and homosexuality quotas in the DFL Constitution enforced by state statute. But before this could happen, Judge Franken began engaging in a campaign which not only excluded the Independence Party major party nominee, contestant from any debates for the office he was running for as the incumbent, but advertised it to the media, pretending he somehow had legitimate authority to disinvite his opponent, like Fidel Castro or something. Now, this began before the state fair was even over in August 2014. Judge Franken lacks this authority under law, but there is no enforcement in Minnesota's congressional elections, even though this completely violates the United States Constitution and undermines and sabotages our federal democracy and our state's obligation to be duly represented based on lawful, valid elections. Therefore, without having time to seek the voter email addresses denied by the DFL Chief Elections Officer Ritchie, or to contest the unconstitutional Minnesota voter quotas in the DFL Constitution and enforced by Minnesota statutes, contestant was left with a stark choice. Either sit by the sidelines of these sideshow so-called debates Franken put on with his partner Mike McFadden, or fight back. To sit by would be to diss all the independent voters in the state. And this panel's bungling of the legal process required by the U.S. Constitution and state laws, even in the event that it was simply a well-intentioned, high-minded misapplication of both, also disrespects Minnesota independent voters. It is no disrespect of the Minnesota courts, including this panel and the judges selected by Chief Justice Gildea, to say that if the contest excludes judges, it excludes you from making the decisions you have. And since you have disregarded this, you must remedy it. And the illegal actions and its consequences must be stayed because you had no authority to take these actions in the first place. And Judge Franken, one of the senators actually in a judicial capacity, has dishonored the role of judge by his self-interested interference, together with his duopolistic partisan, Mark Ritchie. The two have acted in a purely partisan, undemocratic, unconstitutional manner which must be remedied, and certainly may not be validated by the entry of any judgment that is entirely disallowed by law and constitution. Now the argument. Relief from void judgment is available when trial court lacked either personal or subject matter jurisdiction. A void judgment is one which has merely semblance without some essential element, as when court purporting to render it has no jurisdiction, or otherwise is lacking in some of the essential elements which would authorize the court to proceed to judgment, or it acted in a manner inconsistent with due process. This is recorded under U.S. Code's annotated constitutional amendments 5 and 14, both invoked here. Extrinsic fraud is a broad concept which covers a number of situations. Its essential characteristic is that it has the effect of preventing a fair adversary hearing, the aggrieved party being deliberately kept in ignorance of the action or proceeding, or some way, other way fraudulently prevented from presenting his claim or defense. Now back to Solicitor Cox dealing with Richard Nixon. Solicitor and Prosecutor Cox Supra, reflecting on his experiences prosecuting another federal election official, former President Richard Nixon, for his conduct of his election campaign, reflected in Court and the Constitution on the voluntary nature of the rule of law, which burst into the open with the constitutional rift in that case. And there is a serious constitutional rift in this elections case, which I have characterized as the Wild West of election law, or as John Taylor, a friend of Thomas Jefferson, who wrote on the subject, restraint of political law. Franken's election and the related termination of the major political party status of the Independence Party is invalid because it is based on the stated grounds of violation of the political law intended to restrain political parties and partisan candidates and officials during the conduct of those elections. Allowing this purported determination of the rights of parties, really the people of the United States, to go into effect would further loosen those restraints. Essentially, the panel at best demonstrated you do not know about, or perhaps don't care about, freedom and liberty and the most fundamental rights in America, the basic frame of government. You're acting arbitrarily and with caprice, in violation of due process of law, equal protection of the laws, here applied to the major political parties in Minnesota and their candidates and independent voters, the First Amendment rights of freedom of political expression and political association during a federal election conducted in the state, and congressional statutes regulating elections, including the equal time requirement for broadcast of federal candidate debates to the public during elections. And you demonstrate a recalcitrance to support violations by contestees, which has been evident since this conflict started in the 2010 elections, or at least it really started in 2012 elections. But it does go back to the 2010 elections. Now, you're voluntarily undermining, and this motion is to freeze in place the relations and rights between the parties to preserve the rule of law and the basic frame of government and individual rights so democracy can continue in Minnesota. Reflecting on his duty to prosecute Richard Nixon, Cox remembers looking for guidance in another conflict when he was Solicitor General and was asked by Robert Kennedy as the U.S. Attorney General whether he should send troops to Alabama to stop the teachers and students from praying each day in class. Of course not, said Cox, but had no advice when pressed. He says he should have answered, Mr. Attorney General, often there is no satisfactory answer to the question, how should the law be enforced? Either because there is no physical power, or because the use of the only available power is morally unacceptable. Constitutionalism works. Our liberties are protected, and our society is free because officials, individuals, and the people as a whole realize that liberty for the weak depends upon the rule of law, and the rule of law depends upon voluntary compliance. When the test comes, that realization must be strong enough for the people to rise up, morally and politically, and overwhelmed the offender. The roots of constitutionalism lie in the hearts of the people, is what he should have wrote. By definition, independent voters are the weak, but it was not always so. In party politics, Lurie writes of the time before parties, quote, during the first years of the Republic, before the development of parties as we know them today, and he was writing in 1980, the nomination process set in an imperfect way a democratic tone. Access to office was open to all qualified voters with no need to swear allegiance to leader or organizations. Candidates most often nominated themselves. Taylor warned Jefferson against a political appearance parties so baneful to the Commonwealth. The situation of the public or common good in the hands of two parties nearly poised as to numbers is extremely perilous. Truth is not a thing of divisibility into conflicting parts, but of unity. Hence, both sides cannot be right. Every patriot deprecates this union. Others, including famously George Washington, piled on in the same vein. And Lurie describes how the radical centrist, not the party man or party woman, set the tone for a real constitutional democracy, which has vanished from this 2014 election and contest. These are the concerns of Cox as he sat and waited to see if his efforts to obtain the Nixon tapes, essentially determining the case against Richard Nixon, would bear fruit. His concern focused on the constitutional requirements of choosing a president. My concern focuses on the constitutional requirements of choosing a U.S. Senator from Minnesota, while preserving the vehicle obtained with hard work for independent voters in Minnesota. Nixon indicated he would not comply with the Constitution, relying on executive privilege. Franken does not even have anything like executive privilege to rely on. Only his role as the powerful, the rich, against the powerful and the rich against the weak independent voters and parties and campaigns far less conventional and well-funded and organized than his national party role. Both refused to voluntarily comply with the law. And Cox reflected, quote, a presidential refusal to comply with the order of the court would lift the controversy beyond the courts into a trial before the people, as I am doing. But would the people consciously, half-consciously, or intuitively realize that constitutionalism and there for the long run, the bulwarks of their liberties were at risk? Lurie cites Winston Churchill's observation that a democracy must never expose its weakness. You, the Minnesota courts, have refused to apply the law for several election cycles now. The DFL and its congressional delegation in CD4 Minnesota and the Senate race and the mainstream media have refused to follow it, and the restraints of political law have been vaporized, long gone, and the weakness of democracy has been exposed in a way I would never have guessed prior to this experience. Far from refusing to concede, I am the radical centrist fighting in the courts and in the trial before the people to preserve and even restore democracy in this state. This requires the operation of the U.S. Constitution, and I seek it. This motion is to preserve it as much as possible in this panel and this state's judiciary before turning to the United States Supreme Court. It behooves the entire Minnesota judiciary to solemnly establish how its prescribed laws are being followed. The roots of constitutionalism lie in the hearts of the people. Look inside yours and correct this point and point the way forward to following the Constitution and established election laws in future years. Make a historic shift. Conclusion, contestant seeks the voiding of the partial judgment of December 19th and judgment of December 30th. I ask you to reopen the contest, have a new trial, and send findings to the Senate that on post-judgment motions you corrected the record, allowed evidence from all sides to determine whether these election violations are serious and material and deliberate so that they call into question the validity of the congressional and presidential and 2016 elections in Minnesota, and that this is being seriously and with heart addressed and fixed.